What I have for you today is a rather interesting case about service PEs and about how not to litigate a case. You will see what I mean if we go through it. So what you see here is a patent for a hose to bring fuel to the engine of an aircraft, and the patent is filed by Lawrence Wolf, whose name you see up at the top here. And Lawrence Wolf was an aircraft engineer who worked in this business. And we talk about two or actually three decisions. The first one is from the Tax Court of Canada, and it is Lawrence Wolf versus Her Majesty the Queen. And the question was whether he had a taxable service PE in Canada. He was he was a resident of the US. And the court said yes. And then he appealed the decision. And so he went to the Appeal Court of Canada. And again, the court rejected his appeal, and it was decided that he did have a service PE in Canada. And let's see what was going on. First, there was a first case. And this one was from, the previous cases were from 2018, 2019, but in 2002, Lawrence Wolf also had a case, and then it was a question of whether he was an entrepreneur or whether he was an employee. If he was an entrepreneur as a US resident without a PE in Canada, he would not have been taxed in Canada. As an employee, he would have been taxed in Canada. And this time around, he won his case in 2002. The court decided that he was an entrepreneur and not an employee, and the court concluded, this is one of the judges, it was again a three-judge appeal court, and the first judge concluded non-standard employment such as the one of the appellant, which emphasizes higher profit coupled with higher risk, mobility, and independence, indicate that the appellant correctly claimed the status of contractor or the provider of services. This appeal should be allowed. And it's interesting to note that at this time, and this was from 90 to 95, Lawrence Wolf was working in Canada for Bombardier Inc. And if we now look at the facts in the 2018-19 decisions, Lawrence Wolf is an aerospace engineer who specializes in designing fuel systems for aircraft. He was a resident of the US in 2012. For several years, Lawrence Wolf worked as a consultant for Bombardier. In other words, in 90 to 95 he did it, and he was still doing this in 2012. During one of his periods of consulting, he invented a fuel line system for aircraft. And this is what we see the patent for here, I believe. Bombardier Inc. obtained the patent for this invention and transferred the patent to Lawrence Wolf on the condition that Bombardier Inc. would retain a license to use it without paying any royalties. So that was his Canadian business. During 2012, Lawrence Wolf carried on a business as an independent contractor still for TDM Technical Services. This company arranged for Lawrence Wolf to provide consulting services to Bombardier Inc. He was present in Canada from the start of 2012 to August 10, 2012. During this period, he earned a total of $26,244, which is not a lot for the amount of time he was spending in Canada. But that doesn't matter, because next we learned that Lawrence Wolf had also entered into an agreement with Davis Aircraft Products Company Inc., which is in the US. Davis Aircraft specialized in aerospace manufacture and design, and as a part of an arrangement, a limited liability company called Wolf Bend LLC was formed under the laws of New York. For US tax purposes, Wolf Bend LLC was treated as a partnership, but for Canadian tax purposes, it was a company, so it was a hybrid. And Wolf Bend LLC had 5 members. 3 were from the Davis family, so that was Davis Aircraft Products Company, and then 2 were Wolf. One was Lawrence Wolf with 35%. He was, after all, the inventor, and then his brother Stephen Wolf. And then for the year 2012, based on amounts reported by Lawrence Wolf in his US tax return, Wolfband LLC would have allocated a total of $666,000 of business income and $131,000 of royalties to its members in proportion to their interest in Wolfband LLC, and that's about $800,000. And Lawrence Wolf's 35% of the business came to $233,000 for his U.S. income. So altogether, he had quite a nice income, and there was no dispute that Lawrence Wolf was present in Canada for more than 183 days. So these were the facts. And if we just look at them on a chart, you've got US and Canada, Lawrence Wolf living in US but providing consultancy services for Bombardier in Canada, and then you have the Wolfband structure where Wolfband is working for, or Lawrence Wolf is working for the Davis aircraft business, and the payments that Wolfband LLC receives is paid out as follows. And basically, if you look at the contracts that Wolfband LLC was involved in, it is quite clear that it was a bucket. It was not an active business. It was simply a bucket for collecting income and then distributing it to its participants, right? And let's now have a look at the US-Canadian treaty to find out what kind of PE there was. And I must say, considering the time that Wolf spent in Canada, I'm surprised that the Canadian Revenue Authorities did not claim he had a fixed place of business or something like that, but they didn't go for the normal Article 5 PEs. They went for the service PE concept instead. So that was Article 5, paragraph 9, which then says, where an enterprise of a contracting state provides services in the other contracting state. So where an enterprise of the US provides services in Canada, that enterprise shall be deemed to provide those services through a permanent establishment in that other state if and only if, one, those services are performed in that other state in Canada by an individual who is present in Canada for a period or periods aggregating 183 days or more, and two, more than 50% of the gross active business revenues of the enterprise consists of income derived from the services performed in Canada, right? So that is the first alternative to have a PE. You are providing service for more than 183 days in Canada, and it represents more than 50% of your business income. Or you can have letter B, the services are provided in Canada for an aggregate of 183 days or more in any 12-month period with respect to the same connected project for customers who are either residents of that other state, so Canada, or maintain a permanent establishment in that other state, and the services are provided in respect of that permanent establishment. Now, I'm not quite sure why letter B was not in play here, but the only issue was whether there was a PE, a service PE, under letter A, and then we need to look at a number of points. The first one is 183-day rule. That's quite clear that he was there for more than that period, and then the question really was whether more than 50% of his active business revenues came from Canada. And in order to judge that, you need to look at his US income as well, right? But there were a couple of hurdles to take, and we'll just go through them to see what the lower court said, and then we'll get to the appeal court decision. The first thing that the lower court says is that because an individual can have more than one enterprise, the court must next determine whether the revenues generated through the manufacturing and license agreement, that was a license agreement for this Wolfband LLC, were revenues of the same enterprise that provided engineering services in Canada. In other words, so did Lawrence have one business, or did he have two businesses, right? That is really the question. And then the court says, in this case, considering the whole process by which income was earned, the court concludes that Mr. Wolf had only one enterprise. This enterprise consisted of providing engineering services for the design of aircraft fuels. And the court explains the decision a bit and says, a priori, an enterprise whose commercial activities are licensing and sub-licensing, as it was in the US, is different from an enterprise that provides engineering services, which is what Lawrence did in Canada. However, in the present case, the court nevertheless finds that it was the same enterprise because all three commercial activities are directly related to the design of fuel lines for aircraft, right? The product manufactured by Davis Aircraft Inc. and Bombardier Inc. with the assistance of Mr. Wolf are by and large the same. The patent that was used by Davis Aircraft Inc. and sub-licensed to third parties was developed while engineering service for the design of fuel lines for aircraft were being provided to Bombardier. So it's this one and the same patent. The same type of engineering services were provided to both Davis Aircraft Inc. and Bombardier Inc. The degree of interlacing and interdependence between the three sources of income is therefore such that the court finds that both Canadian and US commercial activities were part of the same enterprise. And remember, I mean, in order for Wolf to claim that his Canadian income was less than 50% of his total income, he would have to have this US income there as well. So far he's done well. He's won the first argument, saying that the US income and the Canadian income were from the same enterprise. But now the US income is royalties and license fees, right? So the next question is this really an active business income? Because remember, the treaty talked about active business income. So the revenues must also be generated through an active commercial activity, is what the court of first instance said. As for the income generated by licensing and sub-licensing activity, royalties prima facie qualify as passive income. So maybe it's not part of one and the same enterprise after all. But then the court goes on to say, considering the evidence adduced in this case, the court finds that Mr. Wolf's enterprise, through the action of Mr. Wolf, was sufficiently active in earning licensing and sub-licensing income. And now it comes to what he did for Wolfbend and for getting this license income, right? So with respect to the license activities, Mr. Wolf's responsibilities included the design of in accordance with the patent of these fuel lines, the fuel lines ordered, and their customization for the client's particular aircraft, right? With respect to sub-licensing, Mr. Wolf was required to seek potential sub-licensee, and therefore the third requirement is met because the revenues from all three sources qualify as active business revenues, the business in Canada and the two businesses in the US. So basically there's no impediment anymore to saying you've got to look at the incomes together, and then you think, well, the US income is 233,000, the Canadian income is 46,000. Clearly, the Canadian income is not more than half of the income of the enterprise, but we still have a timing issue. And the court then says the tax court judge found that Wolfbend LLC was not carrying on any business and therefore it did not have an enterprise. So it was also clear that the US activities belonged to Mr. Wolf, just like the Canadian activities, not to Wolfbend, right? Because that was the next question in the court of decision, and we're now looking at the Court of Appeal summary of the tax court decision. And it goes on to say that the court of first instance said, according to Mr. Wolf's testimony and the terms of the operating agreement, Wolfbend was only established for the purpose of collecting and allocating profits generated through the manufacturing and license agreement. So it was a bucket, as I said. In any event, there is no evidence that Wolfbend had a business. The evidence is that the profits generated by the manufacturing and license agreement were clearly those of Mr. Wolf and Davis Aircraft Inc. The most convincing evidence of the existence of an enterprise is the manufacturing and license agreement. Davis Aircraft Inc. was required to maintain records in order to determine the profits generated by the manufacturing and license agreement, not Wolfbend, right? So why, if Wolfbend was a fully fledged business, why wouldn't it contain all those records for itself, for its own business? But it's because it didn't have any personnel, right? It had owners, but it didn't have personnel, so it didn't have an active business. Mr. Wolf was a party to this agreement and Wolfbend was not. Clearly, Mr. Wolf made a business deal with Davis Aircraft Inc., not with Wolfbend. So he got his money from Davis Aircraft Inc. effectively and not from Wolfbend. The court therefore concludes that the payments received by Mr. Wolf from Wolfbend were revenues of Mr. Wolf's enterprise. So they simply reallocate this income to Mr. Wolf, and in effect declare that Wolfband is not the beneficial owner of this income, but a mere conduit. The tax court judge then considered whether this part was part of the same enterprise under Lawrence Wolf and was providing engineering service to Bombardier. The tax court judge concluded that it was all part of the same enterprise, as we saw. However, and this is where things go wrong for Lawrence Wolf, with respect to the determination of the gross revenues of the US portion of Lawrence Wolf's enterprise, the tax court found that Lawrence Wolf did not provide any evidence to indicate when those revenues were generated. In other words, were those revenues generated when he was in the US and not in Canada, because he was a total of 185 days in Canada, and they was therefore almost 180 days in the US as well. He might as well have generated the income there. Therefore, he, Mr. Wolf, was unable to determine the judge, was unable to determine what percentage of the gross active business revenues of the enterprise consisted of income derived from services performed in Canada during the period or periods of time when Lawrence Wolf was present in Canada, right? So he earned $46,000 while in Canada. We have no idea how much he earned from the US while he was in Canada, and it had to be, we know that the total year was $233,000, but the period that he was in Canada, he had to earn more than $46,000 in the US as well, and we don't know whether that happened. So the Canadian court of first instance decided that the amount of $26,000, sorry, I keep on saying 46, but it's 26, earned in Canada by Mr. Wolf's enterprise is taxable in Canada under Article 7 because it is deemed to be attributable to a Canadian permanent establishment under paragraph 9 of Article 5 of the Convention, being the fact that it consists of more than 50% of his total income. So this is how Wolf lost the appeal in first instance, right? And we then see what happens. The case in first instance when he appealed the assessment, and if we then see what happens when he appealed the decision of the Canadian tax court, I mean, things go terribly wrong, because the judge in the Court of Appeal says there are two issues. First of all, Lawrence Wolf raises the issue of whether the tax court judge erred in determining that he did not establish that 50% or less of his gross active business income from his enterprise was earned in Canada, right? And then the Crown raises the issue, so the Canadian Revenue Authorities, of whether the tax court judge erred in determining that the enterprise that generated the profit in the US and the royalties was Lawrence Wolf's enterprise and not Wolfband LLC, right? So there's two issues to decide, and the judge starts with a government issue, and what he says is the Crown submitted that the tax court judge had pierced the corporate veil in finding that the enterprise that gave rise to the profits generated in the United States was Lawrence Wolf's enterprise and not Wolfband and LLC, right? So what the Crown says is you should have recognized that the royalty income and the license fees belonged to Wolfband LLC. They did not belong to Lawrence Wolf, and therefore they could not have been part of his enterprise. You pierced the corporate veil, right? In spite of the fact that the LLC is tax transparent in the US. So CRA looked at the LLC with pure Canadian eyes, and the appeal court is very short. They say the tax court judge did not pierce the corporate veil. Rather, he examined the contracts and other evidence, and he noted that Wolfband LLC was not a party to the contracts. As a result, he concluded that Wolfband LLC did not carry on any business activity in the US, and that the profits generated by the manufacturing license agreement were clearly those of Lawrence Wolf and Davis Aircraft. And the court says, sorry, Crown, but you're wrong. There's no piercing the corporate veil. These profits belong to Lawrence Wolf. And so far, again, Lawrence Wolf is winning the case. But then the tax court judge, the appeal court just reminds us, found that Lawrence Wolf had failed to establish that 50% or less of the gross active business revenues of his enterprise during this period were derived from services rendered in Canada. In other words, he did not show that more than 50% was earned in the US. And the sad thing is, in the Court of Appeals, he apparently still did not do that, because the court goes on to say, while Lawrence Wolf referred to certain provisions of the agreements that had been submitted to the tax court, he did not adduce any evidence with respect to the actual timing of the earning of the revenue in the US. The timing of the earning of the revenue is relevant and is a matter that Lawrence Wolf ought to have addressed through his evidence. Lawrence Wolf did not point out to anything in the record that would support any finding of when the revenues was earned in the US, and one is baffled by this, right? You lose on this point before the Tax Court of Canada, you appeal the decision, and you still don't point out when you've earned your income in the US, which must have been possible through reference of the LLC agreement, through reference of income streams, or anything like that. And one can only wonder whether he did not do it because the numbers didn't support his argument, or whether there was a genuine omission by Wolf and by his barrister in this case. In any case, the Court of Appeal concludes, as a result, Lawrence Wolf failed to establish that the tax court judge made any palpable and overriding error in finding that there was insufficient evidence for him to conclude that 50% or less of the gross active business income from Lawrence Wolf's enterprise was earned in Canada during the period that he was present in Canada. As a result, I, being the appeal court judge, would dismiss the appeal with cost. And so a rather strange service PE case ends with the Court of Canada finding twice that Mr. Wolf did have a service PE in Canada because, one, he was there for more than 183 days, and two, he did not show that he earned more income outside of Canada than I earned in Canada for the same enterprise. I hope you enjoyed the case. I thought it raised some interesting points, and I look forward to discussing another case with you next time. Bye for now.